when the van leaves. Prosecutor spent almost 2 hours giving you his theory. Let me spend you just only a few more minutes giving you mine. When the van enters the lot, just before closing, by the way, Miss Herringa sees it too. The motorcycles see it. Why wouldn't she have seen it? She's even closer and it's coming on the lot. There's no one else on the lot, so she sees it coming in too. She would have noticed that it drove around the back of the building. She's right there. She's looking out the front windows. No way does she go to the back of the building, turn the lights off, and open the door with that van sitting there, and she doesn't know who or what it is. Think about that. She's a small woman. She's all by herself. The guy comes in and turns his lights off, goes the power to the back of the building. Does she turn the light off to go out there and see what he wants? Of course not. Not unless she already knows what he wants. And what she wants, my expectation, my consideration, what she wants is her brown extracurricular, heroin. You see, when you're buying heroin and you're selling heroin, you don't want everyone to be able to see what you're doing. So you turn the lights off. You go around the back. You turn your headlights off. So it's nice and dark and nice and secure, and nobody can see what you're doing. Once the deal is done, she goes back inside. The van leaves. She turns the lights back on. She's the only one who could. There's no one else in the building. The lights weren't malfunctioning that night because we know, because they were on when the police got there. The lights worked, so why were they off and why were they on? Because there was something else going on behind that building that Miss Herringa knew was going on. Why would she open the door otherwise? It's only when the deal is done does Miss Follett and Mr. Barber get back. Those are the two folks on the motorcycle. Remember, they go past the gas station and then they come back. But by the time they get back, the deal is done. And the reason you know that is because when they both testify, what do they say? They say, we could see the tail light, the back light of that van go up and down. From where we were, we could see the back light go up and down. If the deal weren't already done, then they would have seen that back door open. Because if you look at those photographs, the gas station, the lights are all on. It's just like what you expect. It's a convenience store. The lights are all on. If that back door had opened, they would have seen the light of the back door just like they saw the light of the trunk of that trunk go up and down. They never see the door open. By the time Miss Follett and Mr. Barber gets there, it's still dark. The van leaves. They follow the van. The light gets turned back on because that's where Miss Herringa is. Now, after that, I don't know because the evidence isn't there. But here's what I'm guessing. Within a couple of minutes of the deal being done, somebody else shows up at the gas station out front. Miss Herringa arrives, sees the person pull up, and someone else she's expecting, maybe a friend, maybe it's just somebody who she uses heroin with. But she goes out the front door, gets into the guy's car, and she injects herself with heroin. Now she's only going to be gone a minute. It isn't her expectation to go out there and leave out there. Her expectation, she's going to get in that car, she's going to get what she needs, and she's going to come back in. That's why she leaves her purse inside and the money sitting out inside. There's nobody in the store, and she's just going to be gone a minute. She'll come back, she'll finish up. She's got the edge off, she's got that craving going. Now she can go home. But something goes wrong. Something goes wrong. She probably also doesn't want to take her purse because just because you do drugs with somebody doesn't mean you're friends, and it doesn't mean you can trust them. So she leaves her purse inside. She leaves the money inside. She doesn't want this guy, whoever he is, to take from her. She's 105 pounds. Skinny. How much would it take for a person that small to OD on drugs? Maybe when she ODs, the guy panics, he takes off. Maybe he tries to get her some help, and he can't. Maybe she passes. But you know what? No one's looking for him. And there is no video. And the police are off chasing the van. He disposes of the body. He goes about his business. It's also possible that she just left. You'll have her diary. We've entered in the evidence. We're going to give it to you. I'm going to read some passages I think are appropriate. And you'll have a chance to look at her diary. Obviously, my impression of her mental state is much different than Mr. Hilson's. I would agree with him that she loves her son. But once you read that diary, you also see that she says in her own words that she feels she's a terrible mother and that her son is better off without her. It is possible that she just walked out the front door, got in somebody's car, maybe one of the guys that Mr. Dwyer suspects her of, and she simply left. She leaves everything behind because you can trace her with everything that's in that person. You can trace her with her ID. You can trace her with her debit cards. You can trace her with her cell phone. She doesn't want to be found. She leaves the money for the same reason. If she doesn't steal from them, why would they look for her? That's why she leaves the cash money from the store sitting like that. She wants to go. She's made the choice. She's built to the point, and now she's there. She leaves the $400 in the purse because that's her rent money. That's her last gift to her son. Her son's going to need a place to stay. That's the rent money. She knows it. She just leaves it there for him. But then she takes off. Now there's some argument, some suggestion made that people don't drop off the grid. Remember, I brought up that D.B. Cooper guy, the guy who hijacked the plane and then jumped out, and I talked about how he's never been found, and even though they would have looked for him, et cetera, et cetera. And the suggestion or answer back was, well, he had means because he got that ransom money. He got, I think, 200 grand, whatever it was. He got ransom money, so he had means to disappear. He could go off to, and I suggested a desert island, and no one ever hear from him. And I suggest to you, ladies and gentlemen, he's been gone for 40-some years, but I suggest to you, if the only people that you see on a missing persons list will be rich. In other words, if you needed to have a lot of resources, a lot of money to go missing in this country, the only people you'd ever see on the list would be rich people. And I think we know that's just the opposite. That people go missing all the time in this. As sophisticated we are with all this CGI, with all this stuff we have, with this facial recognition, people go missing in this country, and people go missing all the time, every day. And it's not the rich people that are going. It's more likely someone like this, someone without means. And quite frankly, he'd know that. The detective would know that. He's from the Secret Services. He talked about counterfeits. And counterfeits not just money. It's counterfeit IDs. It's counterfeit. It's fake stuff. So he knows he knows better than most of us here what that stuff is available out in society if you can get to it. Maybe Miss Herringer's in Texas. Maybe she's in the oil fields of North Dakota where they're paying $20 an hour for McDonald's. Maybe she's in Alaska. But the one thing that I stand on is the thing I told you from the very beginning. You don't know any more about what happened to Miss Herringer now than you did when this trial began. You don't know. Lights on, lights off. When that van pulled away, Miss Herringer was in the store, turning the lights back on. Having said that, I do want to discuss some of the arguments that my esteemed colleague has made to you in terms of how he thinks this thing unfolds. Clearly, we have a different vision, don't we? He mentions he mentions on several occasions how Dr. Root testified. And he testified, that was the guy who came in and talked about the insulin, a couple of years ago, it seems like. He came in and talked about the insulin, and he talked about this as a knockout drug. The part that he continually misses when he talks to you about that stuff is the doctor said it takes 4 or 5 minutes for that stuff to work. I said, if you remember, I asked the doctor, we're used to movies where the guy comes up and grabs the person and jabs them in the neck and they fall out. Is this kind of stuff that does that? He said, no, that's not what this is. This stuff takes 4 or 5 minutes to work. And that's if it's potent. Remember, he had testimony that you got to keep the stuff refrigerated or it loses its potency. It is not fast acting. It does not knock you out like they say on TV. If, in fact, insulin had been used, and if, in fact, the doctor's right, it takes 4 or 5 minutes, what do you think the Follets would have found when they came? What do you think they would have heard? Somebody jabs a person in the neck or in the arm or wherever he jabs with insulin. What does she do? She screams her head off because it's not fast acting. Even if her hand is over her mouth, she's going to scream to the top of her lungs. There was never a sound reported by Ms. Follett or her husband. Never a sound. No screaming, no sounds of scuffling, no sounds of twisting. There was no sound. And that's significant. If she's... One of the things Mr. Hilson, I think it's a legend, I'm not going to put questions about, he'll tell you what he thinks, is that when that hood came down and popped back up, that it was Miss Herringa in the back of that van, maybe pushing it back up or kicking it back up. But again, he has the same problem. No screams, no sounds. Nobody sees anybody do anything in the back of that van. You'd expect screaming. You'd expect yelling. And there simply wasn't time. If you think about it, it only took a couple of minutes for Ms. Follett to get back and get into position. There wasn't time for the insulin to act. There wasn't time for a struggle without being observed. There wasn't time to bind a person, to tie a person up. They came right back. And if there wasn't a struggle, and if Miss Herringa turned off the security light and walked out in the dark, how would she have known? How would she have known? She didn't know the van was there. She simply turned off the lights and walked out into the dark. Are we just to believe that's a coincidence of timing? The guy just got lucky and she just happened to walk out at that very moment, and that was how this happened? Or no, she knew he was there. She knew who he was. The second theory is that my client clubbed Miss Herringa with a gun. That it left blood and batteries in the battery cover. He has certain problems with that theory, though, doesn't he? Reenact it in your mind. You club somebody, she falls down, you open the trunk, and then what do? You've got to bend down and scoop her up. You've got to place her in the trunk. And then when it comes down, then she kicks it up and then you put it down again. A couple of problems with that, isn't there? Once that door opens, Miss Follett sees him and sees what he's doing. She never once mentioned that he bent over, lifted anything, loaded anything, looked like he was putting anything away, that anybody looked like they were struggling or pushing back against him. And if she's able to kick over the truck, that means she's still struggling. So he's got a problem in that you don't see what you'd expect to see if what he's telling you is the accurate way things happen. There was no struggle. And then again, who goes back in the building and turns on the light again? And there's a bigger problem, isn't there? One of the things we agree on, Mr. Hills and I agree on, there was an eyewitness. There was an eyewitness. Miss Follett sees this. That's not circumstantial, folks. That's direct. That's direct evidence. She sees what's going on. She sees a big guy. She don't say a fat guy. She sees a big guy. A 6-footer. A guy whose head she sees over the top of the van. This guy is clean shaven. He's got long hair, not hair that gets cut every 3 weeks. She's looking right at him. The guy drives by her and her headlight shines right into his face and she sees him. She sees the orange shirt. She sees this guy. And Miss Follett is not like me. Miss Follett remembers faces and remembers names apparently because she knows, she testified, I remember all of my usual customers, my regular customers, I remember them. Okay. And Miss Follett has seen Mr. Willis 3 times. She's seen him at the preliminary examination when he was still fat. She's seen him at the first trial, and she's seen him at this trial. And you know what happened? What do you remember what didn't happen? Remember how Mr. Hilson would say, and did you see the guy that you saw that night sitting out here in the courtroom? And they point over there. Miss Follett has never said, I see him, and that's the guy. This is the guy she saw. This is the guy she saw that night. Clean shaven. And whether or not she agrees with anything else, one of the things she clearly agrees with, he parts his hair right down the middle. The next time Mr. Hilson shows you that mugshot of my client, check out where his hair is parted. Check out, you've noticed it, you've watched him in court today. This is the guy. This is the guy the eyewitness saw that night. Direct evidence. This is the heroin guy. That is not Mr. Willis. Mr. Hilson says, well, look, folks, we got Miss Harrington's blood on the concrete there. Well, yeah, it is. But how long has it been there? There's a report that she received a cut of 2 days before her disappearance. She's a heroin user. How do the detectives tell you they... Right? And part of her job was to carry trash out every day. And there's stuff you can bump against. There's stuff that's scratching. How long has that blood been there? Those of you who have tried to clean blood off a shirt or off some clothing know how tough it is. Those of you who have ever tried to scrub blood off a sidewalk know how tough that stuff is. Unless there's been a lot of rain and there's been no testimony of rain anywhere in the forecast around those times. How long has that blood been there? How do you know? There's also a battery case and some batteries from a Saturday night special. When the prosecutor, when Mr. Hilson, when they're sure something is 655 quadrillion billions to 1, the example I gave their expert had 28 zeros behind it. The battery case, 36. That means they don't know. That means it could be anybody. That means it could be anybody. They have no idea. It might be DNA material, but they can't identify that stuff. Even their own statements say it's uninformative. What does that mean? You know what it means. They don't know whose it is. Which is kind of weird. But we'll talk about that in a moment. If there are 36,000 silver vans in the area, how many guns are there like that one? Cheap Saturday night special. How many guns like that are there out there? How many gun dealerships are there in this county? How many people are coming from other places with that particular gun? How long was that battery case out there? And remember Gary? Matter of fact, Mr. Hilson talked to me about Gary. Gary from Gary's Guns, the guy who talked about it takes some doing to get that battery case off there. In fact, he told you that he's lost fingernails trying. That it's in there good. It's wedged in there good. And the point I'm trying to make is, if someone were to hit another person with that gun, with that 22, then they're going to hit them with the bottom of the gun, right? Or they're going to turn the gun around and hit them with the top of the gun. Because the battery casing is on there so securely, my expectation is if you hit them with the bottom of the gun, the battery case is going to stay on there. The battery's not going to come off. The top's not going to come off. It'll stay intact. So what had to happen, if Mr. Hilson's correct, the guy had to turn the gun around and hit his hearing up with the top of the gun, and that's what jarred the battery case loose. Where's the blood on the battery case? Where is the hair? Where's the makeup? Where is any DNA from his hearing gun on that battery case? I submit to you, if Mr. Hilson is correct, right? He hit her on the head, she's bleeding, and the guy runs away. That means he doesn't have time to clean the battery case off. That means it just sat there and it had all that evidence right on top of it. Ms. Herring's DNA is not anywhere on that. It's not even 36. Let me do this. It's rare in a trial I get to do this, so I'm going to get a chance to do this, folks. It is rare in a trial that I get to commend the guy sitting on the other side for a decision he makes during the course of the trial. And I want to commend Mr. Hilson for his choice not to play those videos for you, the porn videos. They are disgusting. They are disgusting to most human beings. They had images. When you watch that stuff, you can never forget it. It never comes out of your head. You would have been appalled by it. All that stuff is terrible. All that is just you sit. You would have sat there wondering, why would anybody want to see this, much less be involved in producing it? It's just terrible stuff. And I want to commend Mr. Hilson for not showing it to you. And there's other stuff. The swim videos. Now, I'm not refuting that my client took some of those videos, but by the calculation of Mr. Hilson's witness, there were 15,000 videos, swimming videos. And it makes no difference here or there. They're disgusting. You shouldn't have them anyway, either way. But the reality is, if you do the calculation, 365 for the number of days in the year, 365 into 15,000 is over 41 years. You'd have to take a swim meet video every day for 41 years in order to personally accumulate all those videos. My guess is most of them were downloaded from line. He isn't out there every night taking these videos, as might be implied by what you heard. And that, I mean 365, I mean summer vacation, I mean Christmas vacation, I mean spring vacation, where there aren't any swim meets. But it's bad enough that he has them. But my guess is they come from the same place that his video collection comes from, and it too is appalling. And the voyeurism with the neighbors' kids. The sex toys, not to mention Rebecca Bletch. The truth is, my biggest hurdle is, how do I bring you back from all that? How do I talk to you after you've heard all about that stuff and what he does and how he thinks? And that's the difficult. That was the difficult thing in writing this, and I got help. One of my interns suggested that I pose it like this: if this weren't Mr. Willis, if this wasn't somebody with all his baggage, the porn and the other stuff, if this wasn't him, if it wasn't somebody who had another conviction, if it wasn't for the bad acts, if it was just about Harrigan, would you at this point be even close to considering proof beyond a reasonable doubt that, one, she's deceased, or two, that my client did it? And that's really the bottom line. Is he scary? Yes. Is he creepy? Yes. Are you going to invite him to dinner? Never. Are you appalled by what he does and what he likes and he's admitted he likes? Yes. But that isn't proof that he was there with Miss Herringa that night. That isn't proof that Miss Herringa's dead. What about the VIX file? Okay. First of all, the VIX file. What else do you know about my client? You know that he's turned on by this murder stuff. And he's got this murder list, this serial killer list, and he's got this porn, and he's got this VIX files, which he made himself. Ladies and gentlemen, please also note, and that's all fair, please also note that nothing's in the VIX file before the person went missing. Please also search your recollection. If you like this kind of stuff, if this is the kind of thing that turns you on, these are only 3 people in this type of situation over the last 5 years. It's not as if they're local. Is what they have. That's what they have in common. They're local in their situation, and so he's fascinated by this stuff. He's intrigued by this stuff. He researches this stuff. He watches movies about this stuff. But that doesn't mean he's done it. He's done the stuff that they say he's done. It's a morbid. I don't think I need to describe it for you. You know what it is. But it's not proof that he's acting in accordance with it. Just as if you go to a superhero movie doesn't mean that you're going to put a cape on. Just as if you go to an action movie doesn't mean you're going to become a spy. It means that that's his interest. As morbid as it is. But it doesn't mean that he's acted with Miss Herringa in compliance with that interest. Did you notice that even though Miss Bletch was killed months before, maybe even a year or so more, before they found the gun that killed her? No, strike that. I don't think that's a relevant point. My point is there are no trophies from Miss Herringa. There's stuff you find online and there's stuff you find in the newspaper, but there are no trophies from her. And when I'm going to break a promise. One of the things I talked to you about at the very beginning is I'm not going to go chasing after all these moonbeams. That I'm not going to go running down after cases that aren't before you. Miss Herringa's before you, and that's why. But there's just one I can't resist, and that's Miss Shinotola. According to her, on a day when she was working, Mr. Willis came to her house, went directly to her clothes closet, and stole her panties and her gun. I asked her how he knew that's where those things were, and she said, because I told him. As a matter of fact, I asked him how he knew where her panties were, and she says, because I told him. Now, ladies, I'm going to ask you questions. It's rhetorical. You're not supposed to answer. It's rhetorical for those ladies in here who work outside the home, and for those ladies in here who work with men outside the home. How many of those men that you work with have you told where you keep your dirty panties? Fellas, same thing, rhetorical. Your wife has a gun, you have a gun. Are they going to be the same, or is it more likely that your gun is going to be bigger, heavier, more powerful? Well, hypothetically speaking, if you're going to break into somebody's house and steal their guns, and they're sitting right next to each other, and you have your dirty Harry over here, and her lady's gun over here, which one do you think the thief is going to take? He's probably going to take them both, but he's certainly not going to take the little gun. He's going to take your big 44 Magnum, whatever it is, macho gun. Ms. Shinotola said those guns were sitting right next to each other, and he took her gun. Okay. Let's dissect this. Ms. Shinotola wants you to believe that one day when she was working, it just so happened Mr. Willis had that day off, and it just so happened there was enough snow for a snowmobile, and it just so happens that her husband wasn't home, and it just so happens that Mr. Willis knew her husband wasn't home, apparently. And it just so happened that Mr. Willis has learned how not to leave tracks in the snow. In other words, when he jumps off the snowmobile to walk into her home, he's learned how to not make any tracks in the snow. And it just so happens that he's learned not how to drip water on the floor when he does this. And it just so happens that the door was unlocked and Mr. Willis knew about it, even though Mr. Willis has never been to her home, never had a social visit at her home. And it just so happens that he knew exactly where she keeps her dirty panties. I didn't ask her how Mr. Willis knows about that tattoo that she has where the sun doesn't shine. Here's what really happened. She either gave the gun or sold the gun to Mr. Willis. And the panties she gave to him because he asked her for them. And when the cops arrive and inform her, by the way, ma'am, the gun that's registered to you is a murder weapon. So how did this guy get it? He must have stolen it, officer. Because she's not a lawyer. She doesn't know if she's in trouble. She doesn't know if this gun, if her giving this gun to this guy gets her in trouble. She's not a licensed gun dealer. She's not licensed to buy or sell guns. She doesn't know. What she knows is she in trouble? If she says she sold it to him. So naturally, of course she says, he stole it. He must have come in and went straight to my clothes hamper and knew where all my dirty clothes were, and that must be it also. And left the big dirty hairy gun sitting there, by the way. But I digress. Even if you believe he stole the gun, what does that got to do with Jessica Harrigan? Part of what it's got to do is just to dirty him up. You understand that, correct? Part of what's going on here is piling on. This bad act, bad act, bad act, bad act, bad act. Harrigan's over here. But by the time you get all those bad acts, you really don't like this guy. And that's part of what's being done. I'm on my last lap here. Before I've got a couple more things before I get to my last lap, and then I'll almost be done here. You notice when they talk about those, they show those ping telephones, and he was in this quadrant, and he was this quadrant, and his grandpa's house is in that quadrant too, and look at this time, it was this quadrant, and his grandpa's house is in that. You remember all that? All those slides they showed you with those pie charts that look like pizzas, and remember all that? Did they ever show you one time the phone went off when he was at the Exxon gas station? Am I the only one who didn't know that if you turn your phones off, they can't trace you? Apparently that's common knowledge. I didn't. Well, good. Remember the scratches from Clifford Barron? Clifford Barron said that my client had scratches on his wrists, arms, and face, and a deep gouge on his thumb. I think Mr. Hilson brought that out too. So deep, in fact, that he had to go get gauze to put over it to cover those scratches because they're just. And we asked, were they bleeding at the time? No, but they had been. He said these were deep scratches. These were deep wounds. 11 days. I thought it was 11 days, or maybe it was 12 days later. 2 law enforcement officers arrived at Mr. Willis's home. These guys have between them 50 years of law enforcement experience, and they're looking right at him just like I'm looking at you right now. And you're telling me they didn't notice? They know what they're looking for. They knew about the van. So they know they're looking for. They're looking for not only the van, but the indications of a struggle. So they look right at this guy, and none of them put in their reports, and none of them testified to noticing any scratches, any badges, anything on the face, anything on the arms. And this was just 11 days later. Maybe I'm a slow healer, but it seemed to me to have some scabbing, something, even after 11 days, right? But suppose that's not enough. Miss Bishop, my client's ex-wife, she says she's living with the guy at that time, and she sees the guy, and she doesn't see any. She sees scratches on his back, scratches on his leg, places where he'd be wearing clothes, and no one would notice unless they were intimate with him. Okay, she didn't see any scratches on the hand. The day after, the next day, the day after that, she didn't see scratches. She didn't see scratches on his face. Yes, they were living separate lives, but ladies and gentlemen, when she said when she was asked, "Do you recognize this computer?" And she said, yes, it's in our bedroom. They're sharing the same bedroom. No matter if they're estranged, they're sharing the same bedroom. Yes, it's in our bedroom. If he'd have come in all scratched up, and, as they said, she would have noticed. She didn't notice anything like what Mr. Barron described. Here's what I'm suggesting. I don't think Mr. Barron's lying. I think Mr. Barron, this happened 5 years ago, and he's simply confused about the dates. Remember, they kept having these commemorations. They kept having these vigils for find Jessica Herring, right? And when would they most likely have a vigil? Well, they probably had it on the anniversary of her disappearance. And what's the anniversary of disappearance? The day after his wedding anniversary. So every year, they start having these vigils. The press starts covering it. It starts appearing on the news again. People start talking about it. It's the day after his anniversary. And what my guess is, the man's not lying. He's just got the year mixed up. It was probably an anniversary occasion when he saw these scratches, not the day after, because his wife would have seen them and the cops would have seen them. He's not lying. He just got the dates confused. My client works third shift. Those of you who know people who work third shift notice something about them. They tend to stay up. They tend to have difficulty sleeping at night. They watch TV all night. They on the internet all night, and even on their days off, their bodies just, especially if they don't have small kids in the house. Why would their bodies go back? They just got to go back that third shift. And if you're on third shift, you eat at night. And when you're on third shift, you build dog houses at night. That's when you're awake. That's what your body used to. Your body becomes accustomed to it. And the last thing before the home stretch here is the incongruency of this thing, right? You notice how he's such a clumsy criminal. You notice that he's such a... He keeps the Bletch gun. He keeps the child porn. He keeps the insulin. He keeps the panties. He has DNA from half the people in Muskegon in that van. He has the sex toys. He has the van still. He lies all the time to the police and gets busted all the time. He's such a lousy criminal. And yet, not one smidgen of DNA from Jessica Herring, not one. Ladies and gentlemen, if the prosecutor is correct, Jessica Herring spent more time in that van than the other people he's talked about. Everybody except for Mr. Willis himself. She spent the most time in there. And if he's right, she would have had a bleeding wound when she was in there. How much DNA did they find in his van? Not of hers. How much DNA did they find at Grandpa's house? None of hers. There was all these other folks, and yet she is conspicuously absent and fine. Is he that good? They found his porn. They found his stuff up in the rafters. They found stuff in vents. They found stuff everywhere. They found stuff all through the car, the truck. Man. Except for Jessica Herring, they don't find anything of hers. It's just incongruent, isn't it? It just doesn't add up that someone will be that bad with all that other stuff and this good with Miss Herring if he'd taken Miss Herring. And you'll note when I finish, when I finished my case, I didn't put any witnesses on. That's because the witness I want to put on for you is Miss Herring. That journal, you'll all get copies of it. It's admitted evidence. We've got 12 copies, enough for everybody. But what I ask you to do is take a couple minutes. I've looked through it, and there are a couple of sections that I want you to pay particular attention to. And I'm just, it'll take a couple of minutes, but I think they're important. Page 34 of the journal. Another day in paradise. Just let me sleep through it. Stay in bed with blankets and pillows and darkness. Wake me when my son is happy and his daughter isn't here. Wake me when the crooked bitch that straightened out and has straightened out and leaves peace be. Let me sleep until pettiness of past lovers doesn't override the mourner's need for comfort. Wake me when I can communicate all the anger and craziness jumping around in my head. My dream is to sleep all day. Such an easy hope that I'll lose my simple life. Wake me when I can have an orgasm induced by someone else's hand. I want to lay in bed until the sun shines while it rains candy-coated raindrops. Wake me when I have the imagination to keep a 3-year-old entertained all day. Page 6. How does it hurt so much? How does love hurt so much? I've done many bad things, but mainly I've hurt myself. So why do I get more pain for the pain I've caused myself? Page 7. Why does it hurt so damn bad? All caps. Page 13. It's odd saying something to just piss someone off and realizing afterward that it's true. Dakota has treated me better than my family ever has, and that's not a pleasant thought, since it's true Dakota has never treated me well. Even with my mom, I'm still trying to forgive and forget. What kind of mother kicks out her pregnant daughter? What kind of grandma doesn't stay and hold her grandson the day he's born? I just don't understand. I don't know if I love these people. That's sad. Page 24. I don't want to do drugs anymore, and that's the only thing that makes him happy. I see him smile more in an hour that he's high than I see all day. He doesn't lift a fucking finger to help with chores. I have to fucking ask him to do something so I don't throttle his ass when he's plopped on the couch. We barely have sex anymore. He can never put shit back where he got it. I don't know how long I can handle this. Page 32. He barely knows Zevin. I just don't know what to do. I want to be nice and happy and please him, but when I do, it doesn't make a difference on how he is to me. I want to do all the things for him, but it doesn't matter. No matter what I do, he still leaves all his shit lying around. Never puts stuff back when he uses it. I have a system for everything, and he never follows it. I feel like marriage is never going to happen. Hell, he's probably saying that. He's probably staying with me because of Tess and Katie. He doesn't want Katie to say, I told you so. I'm sick of my life and this shithole house. Does he really love me? Does he think he loves me but doesn't? How can we be in love yet so vile towards each other? He makes me so angry all the time. He's so selfish and lazy. He comes home and does absolutely nothing. The only attention he gives Zev is when he's doing something wrong. Then he wonders why Zev doesn't want anything to do with him. We don't know how to communicate. I just don't know what to do. Page 31. I was ready to call it all off yesterday. Just end this whole charade we're playing. Dakota's staying with me because if we broke up, he'd have nowhere to go. He doesn't trust me, he barely has sex, and I'm always making him have a bad day. Why would a person stay with someone who's always upsetting them? If it wasn't for Zevin, I don't think we'd be together. Neither one of us is very happy. We barely spend any time together. He gets out of work and just plops his ass on the couch. Page 46. Anyway, it's been a very, very long time since I've written properly. You have been in hiding in a tub in the basement. So since we last met, Dakota found out about my Brown extracurricular. I'll read that again. Dakota found out about my Brown extracurricular. I miss it. I don't want to do it anymore, but I do miss it. When Dakota found out, a few awful things happened. He broke my jewelry from my day. He pulled my hair back and was somewhat on top of me. I had to pull his hair and push him off with my feet. Worst of all, he pinned me face down into the bed with his forearm against my neck. And Zevin walked in. 3 years old. and the child has seen physical abuse. Page 35. Days are longer and hotter, and my imagination is getting shorter and colder. My sex drive is getting higher and higher, with only my fingers for interaction. And fingers can't climb very high. Can I spend the rest of my life with someone who has such an uncontrollable temper? Can I allow Zevin to grow up witnessing all that anger? I don't want Zev to lose it like his father. He already has a temper problem. Then he sees us acting like damn cavemen. I'm just feeling so lost. I feel like I was right all along in not wanting kids. I think too often about wishing I wasn't a mother. I wouldn't take anything back. Zev is my world. I just feel like he deserves better parents than the ones he has. I feel like I'm never going to be able to give him the good life. When he gets bigger, am I going to be able to afford extracurriculars? Is he going to be the kid that never has cool stuff, up-to-date stuff? Dakota probably doesn't think about any of it. Shit. I'm not sure he has a deep thought process at all. Can I marry someone who just simply doesn't think or remember to try? Why do I love him? Is this the best choice for my son and I? Time will tell. And then finally from the journal, page 8. The thing I love the most, I hurt the most. I put in harm's way the most. I've angrily covered his mouth. I've angrily shook it. I've hurt the most innocent thing in the world with my selfishness and greed and hatred and confusion. I need to let him go, or I will hold him back. I will make him cry and abuse him just like my mother did me. I won't mean to. My emotions just, and the next part is illegible, I couldn't read it. I never wanted this. I've always, and against illegible, stop but I can't. I have no self-control. And it's illegible. And then in all capital letters, better off without me. Ladies and gentlemen, please base your verdict on the evidence. This situation reminds me of a situation, that I think is appropriate. Back in World War II, there was a guy named General MacArthur, and he addressed Congress. And at the Congress, there's this famous line, old soldiers never die, they just fade away. And having read that speech, to me that's not the best line of the speech. To me there's a better one. And it goes something like, I'm an old soldier who did his duty as God gave me the light to see that duty. That's a much better line. As he aged, he made one last public appearance at West Point. That's where the Army trains his officer corps. And that's what they call the Corps. When he says the Corps, he's talking about the Corps. And the last line of that speech, he talks about as he lies down and he takes his last breath, right? And the Lord's going to take him. He said, I'll be thinking of three things. The Corps, and the Corps, and the Corps. And really what he's talking about is duty. Really what he's talking about is duty. And I bring that to you to remind you. You are now members, you are now part of the greatest system of justice in the world. You're part of the greatest system of justice in the history of the world. And while you hear in the news about, well, this guy was, things happen in a courtroom that aren't commendable, the reason why you're hearing about it is because it's so unusual. We have hundreds of thousands, if not millions of trials in this country every day, and you might hear about 4 or 5, 6 or 7 that went wrong that year. The system works. It works when everybody does their duty. The duty, the duty, the duty. That's when the system works. I submit to you, Mr. Hilson's done his duty, and I submit to you, the judge has done his duty, and I've done the best I can. And I'm asking you now to do your duty. Look, we all know what's going on. We're not in a goldfish bowl. We know what's going on and over this case. We know what the public thinks of my client, and a lot of it's justified. We know that. But we can't do what they do because we took an oath to do something different. 2 weeks ago, you stood up and you held up your hand and you said, I swear, I will decide this case on this evidence. It doesn't matter what the popular choice is. I asked several of you, not if there's somebody out there who would disapprove of you if you chose to vote not guilty. I asked several of you, do you care if they disapprove? And you all told me no. This is not about popularity. This is about doing what Mr. Hilson said. Mr. Hilson's told you, hold me to my burden. I accept that burden. I'm glad to take that burden. Make me prove to you beyond a reasonable doubt that Ms. Herringa's deceased and that my client has something to do with it. Hold me to that. And I echo those statements. Your duty is to hold them to it. Your duty is not to care what people think. What evidence did you get? What evidence did you get? What evidence did you get? Not if I'm scared or I'm disgusted. Not if, well, he's done it before, so it doesn't matter. If I'll let Mr. Hilson speak for himself. But what evidence is there? Beyond a reasonable doubt? This is who she saw. Beyond a reasonable doubt? No, I don't think so. My client is guilty of a lot of things, and he is what he is, for whatever reason. But there's no proof that he had anything to do with Ms. Herringa, or even that Ms. Herringa's deceased, from my point of view. People disappear all the time in this country. It's not conclusive. And you need conclusive. That's what beyond reasonable doubt is. It's conclusive. I suggest to you it isn't. I ask you to take a look at those documents that you have. Take a look at all the evidence. And search your heart and tummy of tummies. And do your duty. Do your duty. Do your duty. Not guilty. Thank you, ladies and gentlemen.
Okay, Mr. Johnson, thank you. Mr. Wilson.
Thank you, Judge. Well, ladies and gentlemen, I can promise you I will not stand in front of you for another 2 hours. I guarantee you that. And I'm really not going to take a lot of time. I just want to highlight a couple of things. One, Mr. Johnson's initial first part of his closing argument about this whole drug angle, that some unknown heroin dealer came out of nowhere after the Follets followed this van and Jessica turned the light back on. You remember Lieutenant Casher, he just testified this morning, and they looked at that drug angle. They worked it. They beat it to death practically and came up with nothing. There was in his mind, and as he testified, there is no drug angle here. They talked to the people that actually would deal Miss Herringa heroin. They talked to those folks, and it just wasn't there. So to suggest for a second that that's what happened to Miss Herringa, you know from the testimony that it didn't happen that way. The other thing too is, and again, the judge is going to tell you this, and I think Mr. Johnson said this. You know, what we tell you is not evidence; it's what you saw and heard in this case. And I certainly will disagree with Mr. Johnson's assessment. Every single witness, every single piece of testimony, every single exhibit, all 201 of them, is a piece of evidence that you can use in holding me to my standard of proof. Not just some of them, but every single one of them. And in cases such as this, you know, people always ask me, you know, gosh, what do you, circumstantial case, what do you think about that? And I always embrace those cases. Why? Because it's like, if you ever had kids or you yourself, you bought those Lego sets, and when you open up those Lego sets, it's all a bunch of colored bricks and all these other pieces, and ultimately as you go through the instructions and you put the bricks together, it starts taking shape and taking form, and eventually at the end it turns into the shape that looks like it's on the box. And that's what a circumstantial case is. Each piece of evidence in this case was a brick. And as the witnesses were presented to you and as they testified and as we've talked about in closing argument, it was putting those bricks together. And ultimately that Lego shape took the shape of the defendant's guilt. You know, what I found interesting is that throughout Mr. Johnson's closing, he touched on a few things about the prosecution's case, but not every single one of them. Really didn't go after Larry Brooks and his analysis of the Board Coin video or the analysis of investigators of the video leading up to the Board Coin video. He didn't attack that. Quite honestly, you guys are the arbiters of the facts. In other words, you decide what you remember you heard and what you didn't hear. Not what we said. If, for example, Ms. Follett didn't say that she saw anybody behind in the back of the van. In fact, she said she saw movement, but she didn't see anybody, if you remember, until the individual, the male, broke the corner of the back and the side where the light was. That's the first time she saw that individual, not behind the van. She saw movement, but she didn't see anybody. So I just want you to be careful about some of the presentation. Again, there are certain aspects that I could go over, and I just don't. I'm not going to harp on it. I will say this: is that when we look at things that are tied to Jessica Herringa, you cannot. Although Mr. Johnson did a good job of trying to fluff it, you cannot overlook certain things. This gun. Again, I go back to this idea that if the defendant legitimately got this gun, legitimately, why is he lying about it? Why is he telling investigators when they ask him, hey, look, do you have any other guns besides that registered bursa that is in your house? And he says, no, I don't have any guns. No. But today, defense wants you to believe that he got it legitimately. That's the story you need to go with. That's the real story. That Miss Notella was afraid that hell was going to come down on her. Well, let's think about that for a second. This case, these investigations have been going on since May of 2016. Miss Notella has been involved with law enforcement from May of 2016 till May of 2018. Do you really think she was worried about getting in trouble if she sold the gun to the defendant? No. Not a chance. Not a chance. Not a chance. You can't brush over the VIX file, folks. This explanation that he's fascinated and is a collector because of his, certainly he's a collector. There's no question about that. But there have been several high-profile abduction and murder cases in this nation, yet he doesn't have any of those anywhere in his computer files. This idea that it's just because he's fascinated by it and he's interested in it is, quite frankly, just not true. And really the last thing that I want to touch on, ladies and gentlemen, is this idea that I think one of the biggest things that Mr. Johnson stayed far away from, that's displayed for you on the screen right now, is this password change. This password change and the date that's associated with it. I think it cannot go unnoticed that 4/27/13 is significant in the defendant's mind, tied to the initials JLH for Jessica Lynn Herringa. And the only conclusion that we can draw from that is that that's when she died. That's when the defendant killed her. And it seems to coincide again with the phone records we have, if you think about it, because she's taken in the late evening hours of the 26th, and his phone is still pinging by the phone calls coming from or going to his house on 4/27. So, folks, again, You have paid very close attention to everything in this case. And the court will tell you when the court instructs you that, again, every piece of evidence is relevant. Every piece of evidence is at your disposal to decide this case, whether it is another act that he's not on trial for or the one that he is on trial for. Every single piece. So my request to you is that you use it. Use it all. Because that's what it's there for. That's why the court allowed you, the trier of fact, to hear it. So, folks, as you go back, obviously, listen to the instructions, read the instructions, but in the end, I'm convinced that the evidence will convince you that we've put together that Lego, that building, all those building blocks have been put together, so that you can find the defendant guilty of not only first-degree felony and premeditated murder, but also of kidnapping Jessica Linda Harrington, because that's exactly what he did. Thank you.
Okay, thank you, Mr. Hilson. And I want to tell you now that all of the arguments and the evidence have been completed in this case. And I'm going to give you the instructions that you need to go about on your deliberations. But before we go any further with this, you will remember that we have 14 of you in the jury box, and only 12 of you will be deliberating on the verdict. So the bailiff has put the numbers of your seats, 14 numbers. Wait a minute, we need to get them back in their correct seats now, though, right? So, yes, sir, could you folks go back to the seats that you're supposed to be in, please? And in any event, we have your numbers in there based on your seating, and we're going to just draw a number out of the box and a couple of times here to find out who the two people are that won't be involved in deliberations. So if you want to pull the numbers out, go ahead.
Juror in seat 1.
Okay, that would be Mr. Guy, Miss Guy. Okay, thank you, ma'am. I wish to express our appreciation to you on behalf of the community for giving so much of your time to this civic responsibility. You're entitled to leave now if you wish. If you have anything back in the jury room, please make sure you remove that. If you need any verification that you've attended all these proceedings for the last couple of weeks, they'll provide that to you on the 6th floor. You're certainly free to talk to anyone you wish to now about the case. You're not obligated to do so, however. And if anyone presses you on that and you're uncomfortable with that, please let the bailiff know, and we'll make sure that that conversation comes to a conclusion.
Judge,
okay?
Do we want to, I mean, there's a lot of media attention, a lot of media people here. Until the jury reaches a verdict, do we want to not let that, I mean, I don't want this poor juror to be bombarded.
Well, that's what I just said. If you're uncomfortable talking to anybody, the bailiff will make sure to it that that conversation doesn't continue. Okay?
I think you both wait for me back there, Judge.
All right. So let's draw the next number.
Juror in seat 8.
Okay, I have that as juror in seat 8 being Miss Broadbent. So the same courtesies and expressions of appreciation extend to you also, ma'am. Okay, thank you. The bailiff will be assisting you. And as I say, if there's anybody who creates a problem for him, we'll take care of that. All right. So now we know who the 12 are. And now you know who you are. And you've taken an oath to render a true and just verdict here based only on the evidence and on my instructions. And so you're not going to be allowed to let sympathy or prejudice for one side or the other here influence your decision in any way. And remember, all of these instructions that I give you, just like the preliminary instructions, will all be provided to you in writing, so you don't have to worry about memorizing anything here as we go through this. Now, your role, as I told you at the outset, is to decide the facts. In other words, what happened here. That's your job, not mine. You're going to have to think about all of the evidence and decide what each piece of evidence means and how important you think it is for your decision. And this includes, of course, whether you believe a witness and what each of the witnesses said. And what you decide about the facts in this case is final. Now, it's my duty to instruct you on the law. We don't expect you to know the law when you come here. And you have to take the law as I give it to you. And if an attorney here has said something that differs from what I tell you, you have to follow what I tell you. At other times in the trial, I've also given you instructions. and you should take all of the instructions together, and they perform the body of law that you are to follow. So don't just pay attention to some instructions and ignore others. And so your job is to decide what the facts are and then apply the law to those facts as I give it to you, and that's the way you go about the process of coming up with a verdict. Now, Mr. Willis, as with any person who is accused of a crime, is presumed to be innocent. And that means that you must start with a presumption that he is innocent, and that presumption continues throughout the trial and entitles him to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that he is guilty. Now, the crimes charged here, open murder and kidnapping, as with any crime, are made up of parts or elements, and the prosecutor must prove each element of each crime charged here beyond a reasonable doubt. Mr. Willis is not required to prove his innocence or to do anything. And if you find that the prosecutor has not proven every element of a crime charged here beyond a reasonable doubt, then you must find Mr. Willis not guilty of that crime. Now, when I say a reasonable doubt, I'm talking about a fair, honest doubt growing out of the evidence or the lack of evidence. It's not merely an imaginary doubt. It's not simply a possible doubt. It's a doubt that's based on reason and common sense. Reasonable doubt is just that. It's a doubt that's reasonable after a careful and considered examination of all of the facts and circumstances that you find to exist in this case. Now, when you discuss the case and decide on your verdict, you can only consider the evidence that was properly admitted in the trial. And so it's important for you to have an idea of what evidence is and what is not evidence, because you've seen and heard a lot of things here over the last couple weeks. Evidence consists of the sworn testimony of the witnesses and the exhibits that were actually admitted into evidence. Now, you've seen and heard many things that are not evidence, and you must be careful not to consider them as such. For example, the fact that Mr. Willis is charged with a crime and is on trial is not evidence. The fact that he's charged with more than one crime is not evidence. The lawyer's statements and their arguments are not evidence. They're only helpful to you in understanding their position or theories about the case. And you should only accept things that the lawyers have said here that are supported by the evidence or by common sense and general knowledge. The questions that were asked of the witnesses are not evidence. You should consider those questions only to the extent that they give a meaning to the answers or provide a context for the answer. My comments, my rulings, my questions, my mannerisms, they're not evidence. It's my duty, as I said, to see to it that the trial is conducted according to the rules of law, and to tell you what the law is that you're to apply to the facts that you find to be in the case. When I make a comment or I give an instruction, I'm certainly not trying to influence your vote or express some opinion I might have about the case. If you've come to believe that I have an opinion about how you ought to decide the case, you should ignore that, because you are the only judges of the facts here, and you decide this case, not me, from the evidence. Now, at times during the trial, I have excluded evidence that was offered or stricken testimony that was perhaps heard. Do not consider those things in deciding the case. You make your decision only on the evidence that was properly admitted in the case. And your decision should be based on all of the evidence, regardless of which party may have actually produced it. And in addition to the evidence, you can use your common sense, of course, and your general knowledge in weighing and judging the evidence, but you can't use any personal knowledge you may have about a specific person or place or event. So you decide this case based only on the evidence that was admitted during the trial. Now, facts can be proven a couple of ways. It can be proven by direct evidence from a witness or an exhibit. So direct evidence is evidence about what we actually see or hear. For example, a couple of days ago, if you'd looked out the window there, you would see rain coming down, and that would be direct evidence that it's raining. You saw it, there it is, it's coming down. Direct evidence. Now, facts can also be proved by what is called indirect or circumstantial evidence. And circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if the blinds were drawn, as they are now, a couple days ago, and you couldn't see outside, but you heard peals of thunder, and a couple people walked in the courtroom here with yellow rain slickers on, with water dripping over them and shaking out umbrellas. Well, okay, you didn't see it raining out because the windows were obscured. But when you put all those other pieces of information together, that would give you a reasonable basis for concluding that it was raining outside. And so you can consider circumstantial evidence. As a matter of fact, circumstantial evidence by itself or a combination of circumstantial and direct evidence can be used to prove the elements of a crime. So in other words, you should consider all of the evidence, whether it's direct or circumstantial or a combination. Now, you've heard a couple of times here during the trial that the attorneys had stipulated to something. I heard that come up. When the lawyers agree on a statement of facts, these are called stipulated facts, and you can regard those stipulated facts as true, but you're not required to. Now, as I said before, it's your job to decide what the facts are, and in doing that, you're going to have to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to accept all of it or none of it or parts of it. And in deciding which testimony you believe, again, here we go, rely on your common sense and everyday experiences. But you can't use anything that's related to a bias based on witnesses' gender or race or national origin or anything like that to influence your decision. Now, there were some questions. Remember when we started out? I said there's no algorithm out there for determining whether a witness is telling the truth or not. But there are questions you might consider as you evaluate a witness's testimony that will help you make that decision. Things like, was the witness able to see or hear the event clearly that they're talking about? How long were they witnessing the event? Was there anything else going on at the same time that might have distracted them from the event? Does the witness seem to have a good memory about what happened? How did the witness look and act while they were testifying here in front of you? Did the witness seem to be making an honest effort to tell the truth, or was the witness argumentative or evasive in their answers? Is there anything about a witness's age or maturity that would affect their credibility? Did the witness project any bias or prejudice or personal interest in how the case is ultimately decided by you? Was the witness subjected to any promises or threats or suggestions that might have influenced their testimony? In general, does the witness have any special reason to tell the truth, or for that matter, does the witness have any special reason to not tell you the truth? And all in all, how reasonable does the witness's testimony seem to you when you consider it in the context of all of the other evidence in the case? Now, sometimes the testimony of different witnesses won't agree, and you're going to have to decide which testimony you accept. And when you do that, think about whether the disagreement involves something that's important or not, and whether you think someone is lying or they're just simply mistaken. You know, people see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. Now, you may conclude that a witness deliberately lied about something that's important for you in deciding the case, and if that's the situation as you see it, you can choose to accept nothing that witness said. On the other hand, if you feel that the witness lied about some things and told the truth about other things, you can accept the part you think is true and reject the part you think is not. And you shouldn't decide this case based on which side presented more witnesses. Instead, you should think about what each witness had to say and each piece of evidence, and whether you believe the witnesses, and then decide whether the testimony that you do believe establishes the guilt of the defendant beyond a reasonable doubt. Now, you've heard testimony from the witnesses who have given opinions as experts in various fields here. I don't pretend to give you an exhaustive list, but we had experts in the field of ballistics and DNA and other things like that, other experts. Experts are allowed to give their opinions in court about matters that they are experts on. And I want to tell you that you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is, And when you decide whether you believe an expert's opinion, think about the reasons and the facts they gave for their opinions and whether those facts are true. And you could also think about the expert's qualifications and whether their opinion makes sense to you when you think about the other evidence in the case. You've also heard testimony from several police officers in this case. That testimony is to be evaluated by you by the same standards that you use to evaluate any other witness's testimony. Now, the prosecution has introduced evidence of a statement that it claims the defendant made. And before you may consider that statement that was not made here in this proceeding against the defendant, you must first find that he actually made the statement as it was given to you. And if you find that he did make the statement, you can give the statement whatever weight you think it deserves. And in deciding that, you should think about how and when the statement was made and about all the other evidence in the case, and you can consider that statement in deciding the facts of the case. Now, Mr. Willis, as any other defendant, has the absolute right not to testify. And when you decide the case, you may not consider the fact that he did not testify, and that must not affect your verdict in any way. Now, you've also heard evidence here that was introduced to show that he committed crimes for which he is not on trial here today. And if you believe that evidence, you have to be careful to only consider it for certain purposes. You can only think about whether that evidence tends to show that he used a plan, a system, or characteristic scheme he has used before or since. You can consider it to show intent or identity of the assailant or to establish the fact that Jessica Herring is deceased. You may not consider that evidence for any other purpose. For example, you can't decide that it shows that Mr. Willis is a bad person or that he is likely to commit crimes. And you may not convict Mr. Willis here because you think he is guilty of other bad conduct. All of the evidence must convince you beyond a reasonable doubt that Mr. Willis committed the crimes charged in this case, or you must find him not guilty. Now, let's talk about what has to be proved here. For both of these crimes, remember there's two crimes charged here, open murder and kidnapping. The prosecutor must prove beyond a reasonable doubt that the offenses occurred in Muskegon County in the state of Michigan on or about April 26 or 27 of the year 2013. Now, as I said, Mr. Willis is charged with open murder, and he has pled not guilty to that crime. And to prove that charge, the prosecutor must prove beyond a reasonable doubt that he committed either first or second degree murder. Now, what do we mean by first degree murder or second degree murder? Well, first degree murder includes two types. One is called premeditated murder, and the other is called felony murder. And to prove first degree premeditated murder, the prosecutor must prove beyond a reasonable doubt, first, that Mr. Willis caused the death of Jessica Herring. That is, that Jessica Herring died as a result of an act of Mr. Willis. Second, the prosecutor must prove that Mr. Willis intended to kill Jessica Herring. Third, the prosecutor must prove that his intent to kill was premeditated. That is, thought out beforehand. Fourth, the prosecutor must prove that the killing was deliberate, which means that Mr. Willis considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law doesn't say how much time is needed. It's for you to decide if enough time passed under the circumstances of the case, and the killing cannot be the result of a sudden impulse without thought or reflection. Now, in addition to first degree premeditated murder, you may also consider first degree felony murder. And to prove that, the prosecutor must prove beyond a reasonable doubt, first, that Mr. Willis caused the death of Jessica Herring. That is, that Jessica Herring died as a result of an act of Mr. Willis. Second, that he had one of three states of mind. Either he intended to kill her, or he intended to do great bodily harm to her, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely results of his actions. A third, for first-degree felony murder, the prosecutor must prove that when Mr. Willis did the act that caused the death of Jessica Herringa, he was committing or attempting to commit or helping someone else commit the crime of kidnapping. Now, for the crime of kidnapping, the prosecutor must prove, beyond a reasonable doubt, first, that Mr. Willis knowingly restrained Jessica Herringa. When I say restrain, under the law we mean to restrict a person's movements or to confine the person so as to interfere with that person's liberty without that person's consent or legal authority. The restraint doesn't have to exist for any particular length of time, and it may be related or incidental to the commission of other criminal acts. Second, for kidnapping, the prosecutor must prove that when the defendant did so, he intended to engage in sexual penetration or criminal sexual contact with Jessica Herringa. Now, I've used that term attempt, and to establish an attempt, the prosecutor must prove beyond a reasonable doubt that the defendant intended to commit the crime of kidnapping and that he took some action towards committing that crime but failed to complete it. It's not enough to prove that he made preparations for committing the crime. Things like planning the crime or arranging how it would be committed are just preparations. They don't qualify as an attempt. In order to qualify as an attempt, the act must go beyond mere preparation to the point where the crime would have been completed if it had not been interrupted by some outside circumstance. So to qualify as an attempt, the act must clearly and directly be related to the crime of kidnapping and not some other objective. The defendant must have been either committing or helping someone else commit the crime of kidnapping to be guilty of felony murder. And when we say to help, we mean to perform acts or give encouragement for or during the commission of the crime that aids or assists in the commission of the crime. And at the time of giving aid or encouragement, the defendant must have intended the commission of kidnapping. When considering the open murder charge, you have to consider, or you may consider rather, the lesser charge of second-degree murder. Now, we've got two types of open murder then. One is called first-degree murder, the other is called second-degree. Second-degree murder requires the prosecutor to prove beyond a reasonable doubt, first, that Mr. Willis caused the death of Jessica Herringa, that is, that Jessica Herringa died as a result of an act of Mr. Willis, and second, that Mr. Willis had one of three states of mind. Either he intended to kill her, or he intended to do great bodily harm to her, or he knowingly created a very high risk of death or great bodily harm, knowing that that death or harm would be the likely result of his actions. And you should think about all the evidence in deciding what state of mind there was at the time of the alleged killing. Mr. Willis's state of mind may be inferred from the kind of weapon that was used, the type of wounds inflicted, the acts or words expressed, and any other circumstances surrounding the alleged killing. And you may infer that there was an intent to kill if he used a dangerous weapon in a way that would likely result in death. Likewise, you may infer that he intended the usual results that follow from the use of a dangerous weapon, and a gun is a dangerous weapon. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. Premeditation and deliberation may be inferred from any actions of the defendant which show planning or from any other circumstances surrounding the killing. And the prosecutor need not prove motive for the killing, but you may consider evidence of motive in deciding if there was premeditation and deliberation. Motive by itself, however, does not prove premeditation and deliberation. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances and evidence. Now, you've been instructed then on two types of open murder. And within that is first-degree murder and second-degree murder. And you've been instructed on two types of first-degree murder. And those two types, as I said, are premeditated murder and felony murder. And a verdict in a criminal case must be unanimous. To be unanimous, each of you must agree upon which type of first-degree murder has been proved, or that both types have been proved, or that second-degree murder was proved. And if you return a verdict of first-degree murder, your unanimous verdict must specify whether all of you have found the defendant guilty of premeditated murder, or felony murder, or both. Now, I'm going to give you a verdict form when the case is sent back to you in the jury room. It's going to give you all your options on there, so you'll just have some boxes to check. So that'll assist you in understanding how this unfolds. Now, in addition to open murder, as I said, the defendant is also charged with the separate crime of kidnapping. And to prove that charge, the prosecutor has to prove first that, beyond a reasonable doubt, that Mr. Willis knowingly restrained Jessica Herringa. And when I said restrain, I told you before, restrain means to restrict her movements or to confine her so as to interfere with her liberty without her consent or without legal authority. And the restraint doesn't have to exist for any particular length of time, and it may be related to or incidental to the commission of other criminal acts. The second thing for kidnapping the prosecutor must prove is when the defendant did this, he intended to engage in criminal sexual penetration or criminal sexual contact with Jessica Herringa. Now, those are all the elements of the two charges here of open murder and kidnapping. And when you go to the jury room, the first thing you should do is select someone to be your fourth person, and she or he should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, of course, turn off all your cell phones, iPads, all that stuff. And a verdict in a criminal case, as I told you, must be unanimous. And so if there's going to be a verdict, it's necessary that each of you agree upon the verdict. And in the jury room, you're going to be discussing the case among yourselves, but ultimately each of you will have to make up your own mind because the verdict must represent the individual considered judgment of each juror. Now, when you go through this deliberation process, it's your duty to talk to each other and make every reasonable effort you can to reach an agreement. When you do that, express your opinions, but don't just give your opinions, give the reasons that you have for them, and keep an open mind as you listen to what everybody else has to say. Rethink your opinion. Don't hesitate to change your mind. If you think you're wrong, just try your best to work out your differences if there aren't. Now, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree or just for the sake of coming up with a verdict, because in the end your vote must be your own and you must vote honestly and in good conscience. Now, for the charge of open murder, as I've said, you may consider either first degree or second degree murder, and when you discuss the case you should consider the crime of first degree first. If you all agree that he is guilty of first degree, whether it's premeditated or felony murder or both, you may stop your discussions on the charge of open murder and check the appropriate box on the verdict form. If you believe he is not guilty of first degree murder, or if you can't agree on that crime, you should consider the less serious crime of second degree murder. And you can decide how long you want to spend on first degree before discussing second degree, and you can go back to first degree after you've discussed second degree. That's really up to you. Now, if you have any questions that you have as you go through your deliberations, it's important that if you have a question for me, you need to write that down on a piece of paper. Your foreman should write it out and give it to the bailiff, and then he'll deliver it to me. I'll discuss it with the attorneys, and we'll see if we can answer the question. But you may not communicate directly with me in that process. The possible penalty in this case is nothing that is of your concern and should not influence your decision. It's my duty as the judge to fix a penalty, and I have to do that within the limits provided by the legislature. If you need, as I said, to communicate with me, you need to do that in writing, and that has to be transmitted through the bailiff. It's not proper for you to talk directly with anyone involved in the case from here on out, and that even includes the bailiff. Now, you, as I said, you can talk to the bailiff about housekeeping things, but asking him questions about the case itself or the law or anything like that, no. And he's not going to answer those questions anyway. He's going to tell you can't answer that, so there's no use asking him. As you discuss the case, then don't let anyone, even me, know how your voting stance. So until you return with a unanimous verdict, don't reveal that information to anyone outside the jury room. Now, we have a couple hundred exhibits here at least. If you want to look at any of those, all you have to do is let the bailiff know, and we'll retrieve the exhibits that you need and bring them in for you. You don't have to, but if you do have anything particular you want to see, let us know, and we'll see that you have an opportunity to review that. At this time, I am going to place you in the custody of the bailiff, and you'll be retiring to the jury room. We'll send these instructions in with you, and then very shortly I'm going to have the verdict form ready for you, and we'll send that in with you too. So, raise your right hand. Do you solemnly swear that you will, to the utmost of your ability, keep these persons sworn as jurors in this trial from separating from each other? You will not suffer any communication to be made to them or any of them, orally or otherwise. You will not communicate with them or any of them, orally or otherwise, except by the order of this court, or ask them to agree upon their verdict until they shall be discharged. You will not, before they render the verdict, communicate to any person the state of their deliberations or the verdict they've written on. So help you God.
That's all we got.
When you take the jury to their room. Okay, you want to see the verdict form, gentlemen?
Do you?
Judge, I didn't say anything, but one part of the instructions that wasn't given is
Oh, yeah, okay.
I know you had some questions.
Yeah, so you want to
No. Okay, put it.
put it in the written instructions I give?
Yes.
Okay, yeah, we can do that.
I'm fine.
Right here. I'll do that. Are those verdict forms okay, guys? Okay, then I'll send that in. So I'll have time to. Okay. Yeah, I know what's coming.
And I apologize. I didn't think about that.
Yeah, I need it. We'll get it in there. Instructions that her body need not be recovered if the evidence convinces you beyond a reasonable doubt that she is dead with regard to the murder charges. Is that correct?
That's correct, Judge.
Any objection to that, Mr. Johnson?
No, sir.
All right, thank you. Any other objections or exceptions to the instructions, Mr. Hilson?
No, sir.
Mr. Johnson?
No, sir.
Okay, thank you. We'll be in recess then.
Thank you.
Yeah, I've got a verdict form here, Tom.
Willis. The bailiff indicates to me
You have given the signal that you've arrived at a verdict, and if that is the situation, I would like the bailiff to step forward and take the written verdict form from the foreperson. Okay, the bailiff can publish the verdict.
Please rise. People v. Jeffrey Thomas Willis, case number 16-6040 FC. Count 1, open murder. Guilty of first-degree murder. Guilty of first-degree premeditated and first-degree felony murder. Count 2, kidnapping. Guilty.
Okay, thank you. You may be seated. Ladies and gentlemen, you've heard the verdict announced by the bailiff that you find the defendant guilty of first-degree murder based on both first-degree premeditated and first-degree felony murder. Is there anyone who disagrees with that verdict? Please raise your hand. All right, you've heard the verdict announced that you find the defendant guilty of kidnapping. Is there anybody who disagrees with that verdict? Please raise your hand. All right, let the record reflect that no one indicated disagreement. Do you care to have the jury polled, Mr. Hilson?
No, sir.
Mr. Johnson?
No, sir.
All right, thank you. Then this will stand as the verdict of the jury. The judgment of conviction will be entered. The defendant is remanded to the custody of the Department of Corrections. Sentencing will be on, do we have a date?
We don't, Judge. I believe
Right.
it's June
10th?
It's going to be June 12th.
June 12th? June 12th? Okay. Oh yeah, I'm thinking of pleas. Right, June 12th? Okay. Sentencing will be scheduled then for June 12 at 9:15. And the defendant is remanded to the custody of the Department of Corrections. You may take the defendant. And we are concluded.
Yes.
Ladies and gentlemen, go ahead. Go ahead and take him out. I want to express the appreciation of the community to you for your extraordinary commitment to providing your services to seek justice in this case. This has been a very long and imposing imposition on your lives, and I truly understand that. Your community understands that, but your community is grateful for your being willing to participate in this. And when I say your community, it's not me. You're here for your community. That's what our system of justice is about, is to have 12 people selected from the local community to make these decisions. And I know it's difficult. I have to do this every day, and you're not accustomed to it. So I know it's difficult, it's burdensome, it's hard on your family, it's hard on your friends, it's hard on your employers, it's hard on you. But as long as we have this system of justice in America, this is the way it's going to be. And we're going to call on jurors. We'll start another trial next week, and we'll call another set of folks who will come in and give their time and their effort. And when you think about it, a lot of people fought and died for this opportunity that you had. So when you think about it in those terms, it becomes a little bit more palatable for you, at least. But you are, at this time, discharged from further service. You can go about your business. You can talk to anyone you wish to about the case. You do not have to, and the bailiff advised me that you've all unanimously agreed on something else, that you don't want to talk to anyone about the case when you leave here. So the bailiff will be escorting you out, and I'm going to let the audience know here that the jurors do not want to talk to anybody. And I hope you respect their privacy. They've given a lot of time here, and they're asking to be left alone. So we're asking you to cooperate in that regard, and the bailiff will see to it that they're escorted from the building without their privacy being invaded. Did any of you have any questions you wanted to ask before you left about the procedure or anything? Okay, well, thank you very much for your participation. You are discharged. Make sure you take your things out of the jury room, and the court will stand in recess.